look at the clock and say a good afternoon to everyone in and around this courtroom. Madam Registrar, would you please call the case?
Good afternoon, Your Honor. This is case number IT 0484R77.1, the prosecutor versus Shefqet Kabashi.
Thank you, Madam Registrar. Could I have the appearances? Prosecution first.
Good afternoon, Your Honor. Joanna Corner together with Alma Imamovich Ivanov for the prosecution.
Thank you. And for the defense of Mr. Kabashi?
Good afternoon, Your Honor. Michael Carnavas for Mr. Kabashi.
Thank you, Mr. Carnavas, and see that Mr. Kabashi is present in this courtroom as well. Mr. Kabashi, during the initial appearance on the 19th of August of this year, you did not enter a plea on the counts of the indictment. Instead, you chose to defer your plea as provided for by the rules. And it is for this purpose that the Chamber has scheduled today's hearing. Mr. Kabashi, you'll recall that at the initial appearance, you waived your right to have the indictment read to you, and that I, for the benefit of the public, read a summary. I will now read to you the charges, and then I'll ask you for each charge, how do you plead, guilty or not guilty? And your answer in each case should be either guilty or not guilty, as the case may be. And Madam Registrar will then carefully record any pleas that will be entered by you, Mr. Kabashi. Mr. Kabashi, the charges against you concern two incidents of having contumaciously failed or refused to answer questions when you appeared as a witness. I'd like to invite you to stand. Mr. Kabashi, under count 1, you are charged with contempt of the tribunal pursuant to Rules 77A, small I, and 77G of the Rules, committed on the 5th of June 2007, when you appeared as a witness in the case of the prosecutor versus Haradinaj et al. Here in The Hague. How do you plead, guilty or not guilty?
Guilty.
Under count 2, Mr. Kabashi, you are charged with contempt of the tribunal pursuant to Rules 77A, small I, and 77G of the Rules, committed on the 20th of November 2007, when you appeared as a witness in the case of the prosecutor versus Haradinaj et al. Via a video conference link. How do you plead, guilty or not guilty?
Guilty.
Please be seated, Mr. Kabashi. Madam Registrar, would you please record that Mr. Kabashi pled guilty on both counts? Mr. Kabashi, with regard to your guilty pleas, the trial chamber will further consider whether all requirements of the guilty plea are met to make a finding on your guilt. We have reserved a courtroom for this afternoon for a further hearing on this. Before we continue, could I inquire with the parties whether there is any plea agreement concluded between the parties?
No, Your Honor. There's no plea agreement.
Then it takes two for an agreement. Mr. Carnavas, may I take it that you are of a similar position?
That's correct, Your Honor. And I did want to point out one matter which was brought to my attention by the Office of the Prosecution, that is on the record, to inquire whether Mr. Kabashi has any objections to you sitting...
I'll raise that matter myself,
Okay.
Mr. Carnavas. So, therefore, perhaps you wait until what I say about it, and then, of course, you can comment on it in any way.
Apologies.
Yes. Now, just based on an assumption, let's just assume that the Chamber would accept the guilty plea and would make a finding of guilt later this afternoon. Would the parties be ready to already make submissions on sentencing this afternoon?
Yes, we would, Your Honours. We were, on the basis of the information that Mr. Carnavas was kind enough to provide, anticipating Mr. Kabashi's pleas today. We can deal with opening the case very shortly, and any submissions on sentence, which will be very straightforward. We, the prosecution, make no submissions other than to say that any custodial sentence should reflect the gravity of the charge. We've looked at the authorities. We think it's a matter for the trial chamber.
Thank you, Ms. Corner, for that. May I then take it that you will not call any further evidence in relation to sentence, witnesses or documentary evidence?
That's correct, Your Honours.
Mr. Carnavas, could I hear your position in respect of a possible hearing of sentencing submissions later this afternoon? And again, I cannot anticipate on the outcome of the Chamber on the acceptance of the guilty plea, but just on the basis of an assumption that if it would be accepted, whether you would be ready to make sentencing submissions.
Fully ready, Your Honor.
May I also then take it that you do not intend to call any witnesses or to present any documentary evidence which...
As far as documentary evidence, Your Honor, the only thing that I have provided thus far with the medical records for the consideration of the bench, should they wish to review them.
Yes.
And
they have been disclosed
has them as well.
to the prosecution.
They're always copied, Your Honor. In fact, they had them before you had them.
Yes.
Secondly, there may be a possibility, it's a possibility that there would be one brief witness, which would be the brother who would speak as a character witness, although I have yet to make that final determination.
And that witness is available this afternoon if you would decide to call him.
He's here in The Hague. He's here in the tribunal. He's the brother that came with Mr. Kabashi from New York and has been waiting for these proceedings. So it is our anticipation that we would go forward. It is rather straightforward, and of course we would be looking forward to a final disposition today.
Yes, of course, I cannot anticipate... no, not only not guarantee, I cannot in any way anticipate on whether my colleagues and I would be in a position to even make up our mind today, let alone to pronounce a judgment in court. But
I understand that, but I just wanted to bring it to your attention so perhaps you and your colleagues will know that in advance.
Yes, that it would that you would be pleased if you would know the judgment today. That's
yes.
Yes, that is clear. Is there any other matter before I make a brief statement the prosecution or the defense or you, Mr. Kabashi, would like to raise? And again, Mr. Carnavas, that issue you touched upon already. I'll deal with that after I've given you an opportunity to raise any other matter.
Your Honour, we have no further submissions. Thank you.
Thank you.
Nothing, Your Honour.
Mr. Kabashi, nothing further. I see you are nodding. No?
No,
No, thank you.
Then, as announced, I will, although that's quite unusual, I will briefly address the question of my own impartiality for the proceedings that will follow, and most likely already this afternoon. The Chamber has been made aware of the fact that the prosecution has shared some thoughts with the defense on potential problems with or challenges to the impartiality of the judges on this bench. Triggered by this exchange of views, which I am aware of, I decided to make the following statement. First of all, I can only speak for myself. I have considered whether I would have to recuse myself because of the initial steps taken in respect of the investigation and the prosecution of Mr. Kabashi, such as issuing an order in lieu of an indictment. The Grand Chamber of the European Court on Human Rights decided the case Kyprianou versus Cyprus on the 15th of December 2005. It appears from the submissions of governments that intervened in that case that the common law tradition has widely accepted a role for judges to adjudicate contempt cases if the contempt was committed in court before those same judges. The European Court, and I'm now referring to the Grand Chamber, has, unlike the chamber that first heard the application by Mr. Kyprianou, has intentionally not ruled on the compatibility of that role with the requirement of an independent and impartial court under Article 6, Paragraph 1 of the European Convention. It even declared it undesirable to do so. The decision on the complaint by Mr. Kyprianou was focusing very much on the circumstances of that case. And I read just 2 lines which may be relevant for this. The Grand Chamber said, "The present case relates to contempt in the face of the court, aimed at the judges personally. They had been the direct object of the applicant's criticism as to the manner in which they had been conducted the proceedings." Unnecessary to emphasize that we do not find ourselves in a similar situation. In the rules of procedure and evidence of this tribunal, and more specifically in rules 77C and 77D, judges have been given authority and responsibility to adjudicate and even prosecute contempt cases very much in line with the common law tradition. I am bound by the system adopted by the plenary of judges, and I cannot decide that this system, adopted by many jurisdictions and not declared inconsistent with the requirement of an impartial court by the European Court of Human Rights, that system should not be applied unless I would myself be convinced that I lack the required impartiality in this case. I add to this that the present case distinguishes itself from the Hartmann case in the sense that in that case the contempt charged was not contempt in the face of the court, but committed out of court. I further have considered that a judge should not recuse himself, and especially not in this tribunal where the number of judges is limited, unless there are good reasons to do so. It is on the basis of all these considerations that I concluded that I should not recuse myself. If any of the parties would take a different position in respect of my independence and my impartiality in this case, I would expect them to make an application under Rule 15b small I. And I again emphasize that I've spoken for myself and not on behalf of any of my colleagues in this case. This is the statement I would like to make. Again, if I say I would expect them to make an application in Rule 15b small I, it would certainly be convenient to know if you are considering to make such an application in respect of me as presiding judge in this case.
Your Honour, we are not.
Mr. Canavas.
Had we one, would have been made a long time ago.
Thank you for that, Mr. Canavas. This concludes this. Yes.
Your Honour, I'm so sorry to, before Your Honour rises, I know it's unusual, and it may be out of an overabundance of caution, but I wonder if Your Honour would care to address the accused, which I know is allowed, and simply get him to confirm that he takes the same view as his counsel,
yes.
that he does not intend to make such an application.
Yes. Well, it's unusual, Mr. Kabashi, but because usually counsel is speaking for you, but do you consider at any later stage to instruct counsel or even to take any initiative as to file an application for disqualification of myself or the other judges of this bench, because then we'd very much like to know.
No, on the contrary, Your Honour.
This being clarified, I think we can conclude this status conference. We adjourn until 2:30 this afternoon in this same courtroom. Should this change to a later time this afternoon, the registry will immediately communicate with the parties. We stand adjourned.
All rise. Veuillez vous lever.